Good morning. It's Tuesday the 15th of September, just after 10 a.m. Welcome to the Migrant Law Clinic, Episode 2, LGBT plus Asylum, the Emotional Journey and the Dish Model. My name's Dr S Chelvan. My preferred pronouns are he, him and his. I'm a barrister in the immigration group at number 5 Barristers Chambers here in London. Now, in the chat function on your Zoom platform, you will find in a few moments the URL, the link to the PDF slides of the PowerPoint, PDF document of the PowerPoint slides. Please double click on that link to download the PowerPoint slides for the first session. The chat room will be closed in a few seconds, so please download now. Whilst you're doing that, I'm extremely honoured and delighted that we're joined today by not only refugees and advocates and lawyers who represent migrants and refugees, but also friends and colleagues from the Home Office and the Government Legal Department. Welcome. There are also members and representatives of the European Asylum Support Office, the Swedish Migration Agency, and I'm extremely honoured that we are also being joined today by some friends and colleagues in Australia. So good morning, Australia, from London. Now, some of you have already provided us with some questions prior to this morning's webinar. The sessions are going to be trying to be interactive. There'll also be some opportunities for you to actually interact with some survey questions online. But there's also opportunities for a question and answer session at the end of each session. Good morning, AXA.
Good morning, everyone. My name is Aksa Hussain, and I'm a second six pupil at number 5 Chambers. I'll be assisting Chelvan in this webinar today. As Chelvan mentioned, many of you have already sent in questions, and during the webinar, Chelvan will be answering some of them. Please do continue to send in any questions through the Q&A function at the bottom of your screen. Just to confirm that this morning's webinar is via the Zoom platform, please do make sure that when we start, you have access to the PowerPoint slides located in the chat function and that your screen setting is on speaker view. Looking forward to what is going to be a very insightful session. Over to you, Chelvan.
Thanks, AXA. AXA's a second six pupil here at number 5. She's done some amazing work with me over the summer in relation to 2 applications to the European Court of Human Rights. The first was in relation to an UNRWA refugee from one of the camps in Lebanon as my junior, and the second one she assisted me in relation to a case to the Strasbourg court in relation to the rights of a child to have her biological father named on her birth certificate when she's a child conceived through a surrogacy arrangement. So we're really looking forward to seeing how the European Court of Human Rights deals with those cases. So I'm now going to share the screen in relation to the first PowerPoint slide. So this morning, we're going to be going through 3 different sessions of the webinar. In the first session, we're looking at the legal framework, looking at current updates and historical context in relation to the case of 8J Iran, which is still the binding guidance in relation to how sexual identity and gender identity cases, and more importantly, all protection claims are decided here in the UK. At the end of that session, there'll be an opportunity for questions and answers. There'll be a short intermission between that for about 15 minutes to give people a break. There'll be some fantastic PowerPoint slides created by Jonathan Lee, and which will also include some dish model video testimonials of some of the individuals, including the solicitors Vanessa Delgado and Michael Ferguson, and the human rights activist Adronke Opata will be sharing their experiences of using the dish models in their own casework, or more importantly, in relation to their own refugee claims. The second session will start at 11:15. We'll be looking at specifically at the dish model and how the dish model can be applied to protection claims. Now, let's start with the historical context. I always believe it's very important to be able to look at the lessons of the past in order to prepare for our future. So let's really engage with the concept, the vision in relation to this session, the emotional journey. Now, we're starting off, of course, with our international treaty frameworks of the Refugee Convention, the 1951 Refugee Convention and the 67 Protocol. And let's look at the specific words in relation to the definition of refugee. Owing to a well-founded fear The concept of the issue is in relation to fear, but more importantly, there's different aspects of this journey, the physical journey and the emotional journey, outside the country of their nationality or habitual residence. And this is the outline we're giving here. The physical journey as well as the emotional journey, the fear being subjective, but needs to be objectively well-founded. The lack of effective state protection, that's also linked to the emotional experiences in relation to the refugee, because it's not only unable to avail of effective state protection, but also unwilling. Persecution, the Hathaway definition, of course, serious harm plus failure of state protection. And when we look at one of the seminal cases in refugee convention law, the Canada and Ward case, we look at the issue of international surrogate protection. The underlying rationale of the convention is to require the surrogate state to provide the protection because of the failure of the home state to provide that protection, requiring the refugee to have attempted to avail protection. So that's a very important underlying concept in relation to what we call refugee status determination. Now, when was the first ever recorded asylum case? And when you do download your PDF slides, you'll find that on each of the images, so for example, the fleeing homophobia image on the right-hand side, or any of the cases where it's highlighted in blue, you can double-click on the icon or the case name to take you to the online version of either the report or the case name. So the first noted asylum claim in relation to sexual identity was in 1981 in the Netherlands. And this was researched by the Fleeing Homophobia report in 2011. I was very honoured to be the UK country expert for the report and part of the 5-member advisory panel. So the Refugee Convention is 1951. The first reported case we see of this is in 1981. So we're going to start with our first survey. The question is this: who provided the driving force in relation to the introduction of positive consideration of asylum claims based on sexual orientation identity in the UK? So you've got 5 options: Lord Pannick, Lord Roger, Lord Justice Schumann, Right Honourable Anne Widdecombe MP, or Lord Steyn. So please choose an option on the screen now. About 5 seconds to be able to do so. Okay, so Becky's managing the survey, and the answers are, so 37% think Lord Steyn, and the lowest percentage is to Anne Widdecombe, and we've got quite a few votes for Lord Justice Schumann and Lord Roger. So we'll have the answers in a few moments. If we can take off the survey and then go to the next slide. Now, of course, there are lots of changes in the world in relation to protection of LGBT people. This is the 2018, 2 years ago, September the 6th, seminal judgment of the Supreme Court of India in relation to the decriminalisation of consensual same-sex conduct in India. Now, this is Menaka Guruswamy. Menaka was one of the lead lawyers. It was her submissions which actually turned the court in relation to protecting LGBT plus people in India. Now, Menaka and I actually know each other from 20 years ago. 20 years ago, I remember our heated conversations and debates and even arguments in the human rights seminar of Henry Steimer at Harvard. And what was amazing is that 20 years ago, we were having those conversations, and then 18 years later, she was making those seminal arguments towards the Indian Supreme Court. And the reason why I'm sharing that personal story is that I believe that all of us have the ability, the empowerment to be able to change lives, to save lives through the law. Because we know how it can, in effect, persecute and harm people. Now, this is not a suntan. I was actually born in Sri Lanka 40 plus years ago and came to the UK when I was a 4-year-old. Now, because of colonial laws which have been kept by countries, so this is section 365A of the Penal Code in Sri Lanka regarding gross indecency. Now, in Sri Lanka, there was a constitutional challenge to the laws in relation to discrimination because it was based on gender. The previous penal code provision only targeted men. So there was an anti-discrimination. It only targets men, so it's discriminatory. What did the Sri Lankan Parliament do? In 1995, it changed the law to make sure it included mankind, women, and animals, to make sure that there was no discrimination. So the current law in Sri Lanka is in relation to fines and imprisonment for both sodomy and for gross indecency, section 365A. Now, it's always important to keep up to date with case law, not only in the UK, but also in the host country. So in Sri Lanka, in November 2016, the Supreme Court was dealing with a case in relation to two young men. In 2003, yes, 2003, 13 years before the case gets to the Supreme Court, the magistrates in the Colombo district sentenced two gay men to 12 months imprisonment for gross indecency. They were found in the back of a van. By the time it gets to the Sri Lankan Supreme Court, the Supreme Court says, well, wait a minute here. If you look at the bottom of that first page, and you can double click to the original report in your PDFs, it says, 3658, the penultimate paragraph, was considered by the Sri Lankan Parliament, and it said that, no change in relation to the continued enforcement. They refer to, in the last paragraph, to the change into the criminal laws here in the UK, that in England and Wales, due to the Sexual Offences Act, there was a repeal of those offending provisions in relation to buggery in 2004. Now look at the second paragraph, which I've specifically underlined in this presentation. In these cases, the two gay men had no previous offending behaviour. So what they said is, well, look, as somebody who has no previous criminal history, they shouldn't be having to go to prison. We want them to care and look at that last sentence of that paragraph. Offenders should be given the opportunity to reform themselves. We know in the country information that opportunity to reform is in relation to conversion therapy. That they have to prove that they're no longer gay, and that's the engagement. Human Rights Watch reports has country of origin information which looks at that. It's quite clearly documented. So what does the Sri Lankan Supreme Court do? The original sentence was for 12 months. It doubles the sentences to 24 months, but suspends the sentence for 5 years from the original conviction in 2003. Now, what that means is that if an individual reoffends within those 5 years, not only do they get the 2 years for the second offence, but they'll also have to serve time for the first offence because they haven't shown that they have had the ability to reform. So we have a country in the Commonwealth which is actually saying quite clearly that gay men and lesbians and who offend under 360 and 365 and 365A, and those provisions are in public or in private. So it's not just in relation to the fact that they're caught in the back of a van, have the real risk of being sentenced for 2 years and having to prove through conversion therapy that they're no longer offending for a period of 5 years, because if they come in, they're prosecuted for both ends. So that is state-sanctioned persecution. We're not talking about just one prosecution. We're talking about the Supreme Court of Sri Lanka saying this is how the law should be applied and has been applied. Now, the key message I want to be able to share within this presentation today is that it's not the issue about being LGBTQI. It's about the message of not being straight enough, because there's an alphabet soup of different identities. And mainly these are identities which are predominantly from the global north. So for example, in Jamaica, when words of hate, it's not lesbian and gay. For lesbians, they're referred to as sodomites, and for gay men, batty men. So all this alphabet soup of different identities detracts from the focus of the refugee claim. Because it's not about being LGBTQI, it's about not being cis or straight enough, being what I refer to as the queer refugee, the other, the different. Now, there's a law panic. We all know him from the wonderful Brexit cases of the 2 years ago, a great advocate and somebody we all very much look up to in relation to his passion for human rights and the rule of law in the House of Lords. Now, as before he took silk in 1989, he was the government's lawyer in a case called Bimbassi. Now, Bimbassi was a case which was quite interesting because it involved a Turkish Cypriot. He was a gay man who wanted to get refugee status. And you can see the extracts into that because Mr. Panic, as he then was advocating on behalf of the government. There was a difference between active homosexuals, those who had sex, and those who were not active, and it was all to do with sex in the privacy of the bedroom. Interestingly enough, Bimbassi in his statement talked about being recognised as queer, and he used those words in his statement, it was recorded in the judgment, when he was in the outside world, when he was socialising with his friends. People would identify him as queer. Now, Justice Kennedy, and these are the dark days of the Refugee Convention for LGBT claims, Justice Kennedy made it quite clear that sex is something which the individual can refrain from. He relied on a case called Mendes in relation to political activism in Sri Lanka and said, you don't need to go and be politically active. So Mr. Justice Kennedy in Bombasi in 1989 specifically said, look, the homosexual can refrain from sex. The Refugee Convention does not protect individuals who are conducting themselves in acts which they can refrain from. So that's the state of the UK law. We have to remember that Bombasi is decided at the time of Section 28. 1989, the establishment of the Stonewall Gay Rights Group, it was at a juncture where we were very much fighting for our rights to be able to be equal, not be denigrated under Section 28 of the Local Government Act. So Bombasi is a key indicator in relation to the historical context in relation to how cases are decided. LGBT people would not get protection because they were specifically designated and identified in relation to conduct rather than identity. Then you have a series of cases. This is Vrasio, a Romanian individual. Now, it's always really important to read the case rather than the headlines, because Gay Times issued an article in relation to Vrasio, arguing that the courts and tribunals were advocating that gay men would need to have medical testing to prove that they were gay. This is actually a comment made by Hoppo to the review tribunal, which was not accepted by the tribunal. It was a submission. Now, importantly, when the case went up to the High Court on Judicial Review, it sidestepped the specific question in relation to how the tribunal had erred in establishing sexual identity and looked at the country of origin information report to specifically decide that there were no risks to gay men in Romania. Then in 1995, we have the case in the Court of Appeal called Sachenkov. Now, Sachenkov was a case in relation to risk from Russian mafia gangs and trying to define the Russian mafia gang and the reaction to the Russian mafia gang as a particular social group. Particular social group, as we know, is one of the 5 convention's reasons. And prior to these cases, it was very much looking at the issue of linguistic, cultural, and ethnic links, rather than anything to do with identity. And as I said a few moments ago in this presentation, one of the seminal cases we have is Ward and Canada. And Ward and Canada looked at the issues in relation to innate and immutable characteristics. I have put a footnote on the slide in relation to the fact that the facts in relation to Sachenkov can actually be now imputed political opinion convention reason. We'll look at the Honduras case later on this morning. So Sachenkov is that decision of the Court of Appeal in 1995. Now, it's interesting to note that in the survey question, only 1% of you, 4 votes, actually said that this person next could have been the saviour to positive decision-making of LGBT claims in the UK. Yes, it's Anne Widdecombe, MP. Yeah, this is, of course, a picture of her on Strictly. But in around 1995, 1996, she was immigration minister. And a question was asked to her, and this is from what was then the Stonewall Immigration Group, which is now the UK Lesbian and Gay Immigration Group. And she was asked a question in Parliament by David Elton MP, following the Sachenkov case, whether homosexuals could be included under a particular social group. And it was her answer on the 31st of January 1996 to say sexual orientation is taken into account in the assessment of individual asylum claims where this is relevant. Once again, pro forma, each individual claim is considered on its merits. And you look at the bottom there, the group is defined by some innate or unchangeable characteristic of its members, analogous to race, religion, national, etc. And 2, there must be a real risk of persecution. Whilst claims based on homosexuality might satisfy 1, then they'd also have to satisfy 2. So this is why I wanted to provide an interesting insight in relation to the fact that not only do we get change through litigation, but we can also get change through policy change. So this was Anne Widdecombe as the Minister of Immigration in 1996 saying, look, the UK is now going to change its reference, its guidance and its approach to claims based on sexual orientation and also include gay men. So it's very interesting that a lot of people think about Lord Steyne. We'll go to the Lord Steyne dicta in a few moments, but it was actually Anne Widdecombe, through a policy change in the Home Office, which affected positive change to asylum claims in the UK to sexual orientation. And here we have the Lord Steyne quote in Shah and Islam. Now, Shah and Islam was a case about two women from Pakistan claiming that they could not be returned to Pakistan because they would face harm at the hands of their husband due to the Zina ordinances and adultery claims from their husbands. I understand that up to the House of Lords case, the claim was based not on particular social group. And it was only when it came to the House of Lords, the House of Lords says, well, what about particular social group? So in that case, gender, for the first time in a seminal case, that's 48 years after the framing of the Refugee Convention, was included within a protected group for the Convention reasons. But within the obiter breadcrumbs of the judicial table, Lord Steyne says, well, practicing homosexuals. I really have difficulty in distinguishing practicing and non-practicing, but that may be a debate for another day, most probably after 9 o'clock. But the point being here is that Lord Steyne said, practicing homosexuals due to their distinct status as discriminated social group. Look at those words, discriminated social group. You need the discrimination before you look at the convention persecution, sharing an innate and immutable characteristic. Innate and immutable, something which cannot be changed or something which cannot be required to be changed. Those are the requirements in relation to the dicta. Then, of course, in 1999, you have Lord Justice Schumann. That was the second result in relation to the favourites on the survey, constructing what we call the Jane Continuum. Within the Jane Continuum, it's accepted. We had all these cases from Europe. We had Dudgeon, then Norris, and then we had Medinus, all deciding quite clearly that even the unenforced legislation created a chilling effect. This is Article 8 of the Convention. But to be a refugee claim, you needed, at that stage, the Article 3 arrest. So what Lord Justice Schumann created, in this case regarding an Indian gay case, was the fact that if the state enforces a criminal law, let's pause there. It doesn't say if the police arrest and detain, but if the state enforces a criminal law. So vis-a-vis, go back to the Galabada judgment in November 2016. That is the Supreme Court of Sri Lanka saying the law is still enforceable. So that comes directly within the Jane definition of enforcing a criminal law prohibiting such activity. They will be a refugee. But once again, go back to the analysis, the approach of the courts. It's based on conduct, based on sex. Then we have very much the dark days in relation to the development of the case law called the discretion test. And it's got nothing to do with political party. You can see that in the subnumeral 3, you have the case of Z. Z was a case in relation to November 2014 with respect to a gay man from Zimbabwe. And that relied on the approach of the Australian High Court, in a case called Appellant S395, of two gay men from Bangladesh. And what it did in effect, and we know that from the subsequent case law, is introduce the discretion test. So if I point a gun to you, would you run towards the gun or away from the gun? Well, it's a fight and flight principle. The majority of us would flee away from the gun. And that's what discretion or concealment is about. It's the fact that you would not run towards a gun, you would modify and change your behaviour. And what the court said in the English courts in interpreting what was within the Australian High Court is that as long as that was reasonably tolerable, then forget the fact that in Jamaica, you're a lesbian, you'll have curative rape or murder, they find out you're lesbian. As long as you fail to establish that was not reasonably tolerable, we could send you back. Now, in that period, decisions were saying, yes, we accept that you're lesbian, gay or bisexual, but as the UK LGIG report failing the grade published in 2010, 98 to 99% of decisions which are analysed by UCLIG found that within the 50 decisions, the majority were refused, not on failing to establish identity, but because of the reasonably tolerable test. The first case I had in the Court of Appeal in relation to that was RG Colombia, which is number 5, whereas a gay man from Colombia, it was accepted that he was gay, accepted that vigilante death squads went round Colombia killing gays, prostitutes, trans people, but because he had not been discovered for 13 years prior to coming to the UK, Lord Justice Buxton held that even though there was psychiatric evidence that he would suffer a nervous breakdown if he had to conceal his true identity, the Court of Appeal held that that still did not cross the threshold for not being reasonably tolerable. And then, of course, we have the last case, which is a J case, which talked about the reasonable tolerability test in its context. It will say it's, looking at the issues of identity. There's Lord Justice Morris Kane. He comes back into our seminar in a few moments. Lord Justice Morris Kane saying, look, it will have to look at what impact the exercise of discretion would mean. But in effect, the courts and tribunals were misinterpreting that to show that you needed to show, in effect, a very high level of psychiatric harm. Not that you wouldn't be able to exercise your life as a human being, but a high level of psychiatric harm. This is a decision of the Court of Appeal in July 2006. Now, when J. Iran is then remitted back to the Asylum and Immigration Tribunal in 2008, and then it's called 8J, and then comes back to the Court of Appeal. Important footnote here is that the judge who granted permission for 8J to come back to the Court of Appeal, and in a case of mine called AM Syria, was Lord Justice Morris Kane. He clearly accepted, by granting permission to these two cases, that the courts and tribunals were misinterpreting what was the J test in relation to reasonable tolerability. Another case which came and joined the cases, AM Syria, there was a consent order. It went back to the tribunal because they hadn't considered the Article 8 human rights claim, was HT Cameroon. In HT Cameroon, this was a gay man from Cameroon, and I was instructed as junior counsel, who was accepted that whilst in Cameroon, he was discovered kissing his boyfriend on a warm summer's evening in Cameroon. Now, that would be nothing unusual in his back garden. It's a late summer's night. Why would that be a problem? It was a problem because one of his nosy neighbours saw him kissing his boyfriend and started spreading the rumours to everyone around that HT Cameroon is a homosexual. Now, Cameroon is a Roman Catholic country, and HT had clear religious faith. So on his way back from church one Sunday, the mob descended on him. And what the mob did was they started shouting at him, calling him a homosexual, a sodomite, and then they started beating him with sticks and throwing stones. Somebody pulled out a knife to try and cut off his genitals. He had to put his hand across his genitals to be able to protect them. He was kicked to a pulp to the ground. The police were called, and the police were saying to this mob, what's going on? Why are you beating this man? Because he's a homosexual. What do the police do? They don't protect him. They join in with his beating. So he's hospitalized for 2 months, and then the Jesuit Canadian priests say, look, HT, and HT had a thriving logging business in Cameroon. So they say to HT, you can't stay in Cameroon. We've got to get you out. We're going to get you to Canada. Unfortunately, at that time, there's no direct flight from Cameroon to Canada. You have to go through this little island of Europe called the United Kingdom. So HT goes to the United Kingdom, transits in London, takes a few days in London, and then goes to the airport to get his connecting flight to Canada. Unfortunately for him, or in line with the law, the immigration officers found that he was using a false passport. So they prosecute him. He's sentenced for 12 months. He's put into prison in Scotland. Whilst he's serving his sentence, he claims asylum, says, look, I can't go back to Cameroon. The first-year tribunal in Glasgow hears the evidence of HT Cameroon, sees medical reports, he's got a perforated eardrum, sees all the scars on his body, and they accept everything. They accept that he is a gay man from Cameroon who suffered persecution. But they're given country evidence not in relation to Cameroon, but the presenting officer gives the case of F and UK, which is a Strasbourg case in 2004 regarding Iran, and says Iran's like Cameroon, and at that time the country guidance wasn't out there to say that gay men were persecuted. And because of that, everything's fine, and in line with the discretion case law, it's fine, we can send him back to Cameroon and he can live somewhere else. And the tribunal, and this is a tribunal review, said, in effect, it was HT's fault for not being discreet enough. It's because he kissed his boyfriend in his back garden, that was the issue. So HT not only loses the first tribunal, but also loses in the review tribunal, the what was then the AIT. When it gets to the Court of Appeal, and there are a few steps which I'm missing here because of the time then, because when he gets to the Court of Appeal, he's joined with 8J Iran, and the Court of Appeal, in extending the reasonable tolerability test, says quite clearly that where there are these laws, these social attitudes in Roman Catholic Cameroon or Islamic Iran, then the individual lesbian, gay or bisexual person must in effect defer to such rules in order to be discreet. So part of the additional limbs required for those individuals was in relation to adherence to the society, to what is in the cultural, religious and social norms. It's got to be one of the most homophobic judgments of the Court of Appeal, because in effect it says the laws in those countries, cultural relativism, you must respect them. And therefore, if in conducting your behaviour on return, you must ensure that you obey those laws which in effect are persecutory or lead to persecution. This is a rather unfortunate decision of the AIT in 2005 by senior immigration judge Freeman, called AT Homosexuals' Need for Discretion Iran. You can read what is underlined in those sections: discretion in their public sexual practices. It in effect castigises individuals who don't apply the social cultural norms as being animals, as being uncivilized. That judgment created a lot of upset with LGBT support groups, for example, Stonewall, and what was then now the UK Lesbian Gay Immigration Group wrote complaints to the tribunal in relation to this paragraph. It was actually used in a lot of LGBT claims in relation to Article 8, saying on the basis of that paragraph, you have no right to freely express your private life in countries of return. I was a trustee of Youth League at that time and wrote an article for the Asylum news section of the following year's report. Interesting enough, and the reason why I'm using this as a tool, it's important that these judgments are not just historical, but can be used if there's an issue in relation to later litigation. So in 2014, Counsel for LH and IP were having a conversation in Taylor House, and he informed me that in LH and IP, Judge Freeman was on the panel. And I indicated that was some concern in relation to what happened with AT Iran. Counsel on the Thursday, Friday, the hearing was on the Monday, Tuesday, was able to use the article, which I highlighted the issues in relation to that, to apply for the judge to be accused because of the perception that he would not be, that he would be biased in relation to LGBT claims, and Judge Freeman was recused from the panel for LH and IP. So it's important that we now step up in relation to judgments such and determinations such as these, where there are later considerations which involve specific minority groups where there is some concern. Nobody's saying it's actual, it's perception. Now, NR Jamaica is a very important sample case. It's that we're starting to get cases which not only just on the male homosexual, but start looking at female sexual identity as well. And NR Jamaica was the first case in the Court of Appeal which established the most important principle. There is an unfortunate bias towards against, and we're not talking about one group, we're talking about anybody who represents LGBT asylum seekers would have heard the tales that where the woman has been married and has had children, clearly she can't be a lesbian. Yeah. Well, we know in those countries of origin, and we'll see this later with SW Jamaica, that the only way not to be detected is to live a straight life. Because unless you live a straight life, questions will be asked, and we call this the politics of gossip. So in NR Jamaica, the Court of Appeal, having heard on appeal a case where an individual, NR, was sentenced in relation to what we now call cross-county drug smuggling, for a very long sentence. She had a history of having been left Jamaica forcibly by her father, having her narrative was gang rape. That was not believed by the tribunal. They accepted that she clearly had left for certain reasons, but didn't accept the history of gang rape. And she started having relationships with women whilst at Yarlswood Detention Centre. And the tribunal below actually said, well, she had no choice. She either was celibate or she had sex with women. And that was a finding by the tribunal below the Court of Appeal in 2008. They were sitting in Taylor House on the Deport case. And the Court of Appeal in this important judgment, and this is binding, it's in the API, said sexual identity is current identity. What would you say to Oscar Wilde? Sorry, Oscar, you were married with Clements and you have 2 children, so you can't be gay. No, it's very important to be able to focus at current identity, because then we don't fall into the trap in relation to our unconscious bias in relation to how LGBT people should be. Now, Devon and Milbank, at the height of the discretion cases, wrote this fantastic academic article, and you can double click on the link to get access to the article in full to say, well, look, why would a heterosexual find this a normal life, to be able to hide who they are, to be furtive, never showing affection to their partner, identifying themselves as a couple of friends or family, and only pursuing their heterosexual lifestyle by having swift and furtive sex? Is this a normal life? There's a lot of great academic work in relation to that. I highly recommend reading the work of Catherine Devon and Jenny Milbank and Nicola Vallette and modern writers such as Senthil Raja and Peter Dunn. There's some really good stuff happening with the academic work. Now, on gender identity and expression cases, we really are falling back. There are only 2 current reported cases on gender identity expression cases, and they're quite historic. The first one is Rahimi, which is 2006. It is a permission application, so it's not in the public domain, but if you need it, please contact me and I'll forward you a copy of the transcript. And then AK Iran, which is a substantive appeal, Lord Justice Moore-Bick in 2008, and you can double click on the link to access that. And Rahimi, and this is Lord Justice Moore-Bick in Rahimi, was talking about the issues that you need to separate sexual identity from gender identity claims. And at that time, there was prior to the country guidance case in 2005, when it was decided in the First Year Tribunal, they were saying that gay men aren't at risk, so therefore trans people. And the Court of Appeal very much identified the issues that you have to look separately at the 2 identities. So these are the issues in relation to the position. They looked at the pre-2005 country guidance position in relation to no risk, and tried to conflate the positions of trans people. And the unfortunate language, those are words transsexuals in the judgment rather than trans. AK Iran is a case in 2008, and there's Lord Justice Sedley looking at the issues in relation to remitting the appeal back to the tribunal below, making quite clear that the error hadn't repeated itself in 2008 from what happened in Rahimi, not confusing trans identity with sexual identity. A lot of care had been taken. There are 3 relevant unreported upper tribunal determinations. We're still waiting for that first reported determination. And you can cite them under Practice Direction 11.2 of the Consolidated Practice Directions. And the first one is EFH. EFH is a Singaporean pre-operative trans woman case, where under Singapore law, you're a woman if you've been born female, or you are a post-operative trans woman. Not if you're a pre-operative. And because she is pre-operative, because of military service, she would have to serve military service she then was doing a continuous military service for 2 weeks for the next 7 years. And we were able to successfully find at the First Year Tribunal, this was Judge Jackson before she got elevated to the upper tribunal, that this amounted to persecution. The Home Office appealed to the upper tribunal, and you have the link in the hyperlink, and it was quite clearly accepted in relation to that there was no error of law. The second one is LSL Malaysia. Only in the past couple of months has the CIPIT now issued a specific SIP-in relation to Malaysia for LGBT claims. We know that there's a huge spike in relation to sexual orientation and gender identity claims from Malaysia in the past couple of years, the majority being allowed either at first decision or on appeal. So LSL is quite an interesting case in relation to the confusion of identities by the potential persecutor, perceived as a lesbian or at risk as a trans man. And the third case, the most recent case, is MKMR, where my client had 2 identities. She identified identified as both as a gay man and a preoperative trans woman using the female pronoun. And importantly, in that case, using the Galabada case at first instance before Judge Lawrence in York House, Judge Lawrence accepted that LH and IP could be departed from, because in LH and IP, looking at the evidence in 2014, there had been, before the tribunal, no evidence of any prosecutions since independence of Sri Lanka in 1948. And what was quite clearly that Galabada actually recorded the 2003 prosecution. Of course, there must have been many others. We didn't get to the higher levels. But importantly, the upper tribunal dismissed the Home Office appeal on the basis, first of all, on the basis that there was no material error of law, let alone material error of law in departing from the country guidance case. So that's very important in saying that LH and IP should no longer apply in relation to that elements, but also in relation to her gender identity, LH and IP also identified real risk on the basis of gender identity. So let's look at H.J. Rahn and the legal framework. I'm going to go through some of these slides pretty quickly because of the time issue, but you have the references there. You'll see the underlying rationale of the convention is to protect all. So you look at the second section of that paragraph, which is the Ward in Australia, international surrogate protection, and the first part saying, look at the terminology, say black, gay, or the descendants of some former dictator. This is the first senior court decision which actually uses the terms, and the Supreme Court were very much at pains to say that this judgment also included those who were lesbian and bisexual. It struck down the reasonable tolerability test on the basis that no straight person would find such discretion to be reasonably tolerable. That discretion wasn't just in the bedroom, but they couldn't even do furtive glances to somebody they found attractive, because of the real risk in relation to persecution. Now, this is what is called the Kiley concert case, because the five Supreme Court justices made it quite clear, and this is Lord Roger, who's no longer unfortunately with us, that just as male heterosexuals are free to enjoy themselves playing rugby, drinking beer, and talking about girls with their mates, so male homosexuals, gay men, are free to enjoy themselves by going to Kiley concerts, drinking exotically coloured cocktails, and talking about boys with their straight female friends. According to the chattering classes, before Kiley, it was Barbra Streisand, then Kylie Minogue, and then just plain Kiley. But isn't it interesting to show that we are equal and different? And that's what's so important, that we may express our identities in a spectrum of ways. The issue is not the expression. The issue is the persecution upon the expression. Now, importantly, and this is important in relation to the Limb 2 analysis, which we'll go to in a few moments, what they said is that when you're looking at the country information, you're looking at the discretion test or the fight or flight, the majority of people would not run towards the gun. So when you're looking at a country, when you're looking at country of origin information, you're not looking at the risk to the general gay population, because the majority of people would be concealing their sexual identities because of the fear of persecution. So you're looking towards what happens to the gay martyr. And when we define gay martyr, we're looking at individuals who are either the activists, those people who refuse to accept the norm, the persecution, or those who fail to conform to the expected narrative of the potential persecutor. So we're not looking at in the general risk, we're looking at the risk towards those who are open. This is Lord Roger at paragraph 59. So summarising the test, and this is LC Albania, we somehow redrafted the test, but we'll look at that later on, is that the first limb, and we'll be covering that in session 2, is the appellant LGBT+, gay, or someone, and this is important, someone who be treated as gay by the potential persecutor in the country of origin. The second limb, which we'll be going into now, is do openly gay people have a well-founded fear of persecution in the country of origin? And then the last two limbs is what we call the conduct limb, limbs 3 and 4. Will the applicant be open? SW Jamaica, the tribunal accepted that the genie had escaped the bottle, that she could no longer be discreet, even though it accepted that there was a real risk of curative rape or murder on return. But for the majority of people, if they will not be open, the Court of Appeal rewriting in effect the HA test, is that if the material reason for living discreetly is the fear of persecution, then they are a refugee, then they should be afforded status. So this is a screenshot of one of the scenes in the Pride movie, and it's an Americanism for the spelling, but I am discreetly gay. So let's look at that in a few moments. So limb 1, prove is or perceived. Limb 2, Do open members of the Convention Reason Group, so as I said, it belongs not just to LGBT claims, but all protection claims, face a well-founded fear of persecution? Limb 3, will the individual be open? Limb 4, if not, voluntary discretion, and why? So part 3, let's look at the second limb. I'm looking carefully at the time. Paragraph 82, when an applicant for asylum, will it be gay or perceived to be gay? Then looking at what happens to those who are open. And this is a cross-analysis with paragraph 35b of Lord Hope. And importantly, the primary source which Lord Hope looks to is the Home Office Country of Origin Information Report. And we look at a recent case in relation to the two sections, because the Country Policy and Information Note is in two sections. You have the country information at the latter half of the report, and then, of course, at the beginning, you have the policy section, where there is a divergence in relation to recent upper tribunal analysis with respect to the weight to be attached to one section versus the second section. So limb 2, those who lived openly, knowing that in a country where there's well-founded fear of persecution, there'll be few martyrs. Yeah. One thing which I'm really interested in is that the issue of the numbers game. Of course, we're never going to have statistics in relation to what percentage of the population is LGBT. And there used to be, the 1 in 10 statistic of Kingsley in the 1950s. But even with 1 in 10, I think Stonewall talks about 5 or 6% in relation to the LGBT community in the UK. So when we're looking at a country of Nigeria of 80 million, okay, so 8 million, 4 million, where are the 4 million LGBT population? Why are they not parading in the streets? Not parading, but living their lives in Lagos or the other major towns of Nigeria openly and freely? I think the numbers game does have an important impact in relation to this, because we know that there will be a certain percentage of the population which will be non-straight, which will be queer. So where are these people living their lives openly and freely? Now, there is the front page, and this is in the public domain in relation to a report I filed in February for the Independent Advisory Group on Country Information. It's over 400 pages. It analysed 31 countries and the Home Office either SIPIN or SIG or policy notes in relation to SOGI, sexual orientation, gender identity or expression. The report will hopefully be laid before Parliament later on this year. I can't say too much about the recommendations or the analysis of the report, but importantly, there have been a few reports which have been published by SIPID since the report, which have improved in relation to their focus and approach. Now, here, for example, is the Afghan SIPIN. I see we're going to slightly overrun on this session, but there we are, the Afghan SIPIN. Now, importantly, the earlier country guidance case is AJ risk to homosexuals. And the Home Office policy using AJ risk to homosexuals until January this year was that, looking at the analysis, they said Kabul would be fine for a gay person to live in, as long as they were the issue of reasonable tolerability in relation to, as long as they did not cause public offence. And it involved various policy considerations in relation to approaches to the Home Office, saying, well, look, that test has gone since July 2010. And only in the last year has the Home Office changed their policy to accept that AJ risk to homosexuals, the 2009 case, country guidance case, when reread through the prism of the Supreme Court case in 2010, actually means that LGBT people are at risk of persecution, even in Kabul. And we see the negotiations which are happening in Doha at the moment, and one of the key elements which the Taliban want in relation to the new order in Afghanistan is strict Islamic law. So we're not going to see liberation of the LGBT plus population in Afghanistan. In effect, we're going to see far more stringent persecution. This is Sri Lanka SIPIN, published in October 2018. I understand that there is going to be a new SIPIN being published in the next couple of weeks or so. It was supposed to be published in August. Let's look at law of practice 4.1.2. We said at the beginning of the presentation, we talked about the issue in relation to the fact that if you look at the last sentence, with a sentence of 2 years rigorous imprisonment suspended for a period of 5 years. Pause. Suspended for a period of 5 years in order to allow an opportunity for reform. That is missing from section 4.1.2. So it's really important that even with a SIPIN, you go back to the original source document, and the URL is actually in the footnote, to show that the reason why it was suspended for 5 years is with the previous issue of non-criminal offending, and more importantly, the requirement for conversion therapy to be able to prove straight. This is the Bangladesh SIPIN note published in April this year. Look at the issues in relation to fear and protection, 2.4.26 and 2.4.27, all about accepting that LGBTI rights activists will be at greater risk than ordinary LGBTIs. Well, they're the only people who are open. We know the murder of the 2 journalists in 2016. SIPIN makes it quite clear that certain people are now under investigation and charged in 2019, some 3 years after the murders. But we don't see a general LGBTI population in Bangladesh. And importantly, in relation to protection, they accept quite clearly in relation to 2.5.5 that the state does not give effective state protection. But importantly, what we need to consider is that not only does the state not give effective protection, but Lim 2 of HJ Iran does not require the individuals show that the state will provide them with protection. So that last sentence, which says, however, each case will need to be considered on its own facts, is not compliant with the second limb of 8J Iran, because that's purely an objective test. And this is the case I was referring to a few moments ago, BH Iraq, which is decided in May this year, where it quite clearly says in the duty of disclosure, there's no duty of disclosure in relation to what we call responses for further information. So there are a certain number of documents which are in the public domain on the COI website of the Home Office in relation to SIPINs or SIGs, country policy information notes or country information guidance. But what you don't have access to is responses for further information or other post-published SIPINs, which are on individual inquiries. So that information is no duty to disclosure, but that's why it's so important to look at the policy considerations, because the policy considerations in SIPIN go directly to the Secretary of State's position in relation to Lim 2 of 8J Iran, because that's what the SIPIN and the SIG is there for, in order to give decision makers and presenting officers a quite clear, unambiguous statement in relation to what the Secretary of State's most recent published position is. So BH Iraq is very important in relation to that, as I refer to requests for further information. So question 2, can the internal relocation alternative be available? Please vote now. Okay, and then let's have the results. 44% no, 28% yes, 28% maybe. Okay, so let's take off the screen and go into this section in relation to internal relocation. So the most recent case in relation to internal relocation with respect to the approach of the Secretary of State is MB. MB was a lesbian from Albania, bisexual woman from Albania who was accepted to be at real risk of harm in Tirana. The family lived outside Tirana, but they had relatives in Tirana. She had been the victim of domestic violence at the hands of her father, so it was accepted that he had, through his relatives, reached to Tirana. The issue was internal relocation. Now, in the refusal letter, the Secretary of State had not referred to the evidence in relation to Skopje, which is one of a university town which the appellant had previous historical context relationship with in Albania. Now, the case is important in paragraph 24 because it says quite clearly, in line with the Qualification Directive, Article 8, as long as the Secretary of State refers to the location of internal relocation, it's a shared duty of cooperation. But importantly enough in relation to COI material, it also says that part of the sources of the country information in relation to identification and fact analysis is from the country information reports. So therefore, we hope that in future, CIPIT will be publishing their SIPINs with a section which says if internal relocation is available in relation to those cases. So, for example, in AJ Iran, the Supreme Court accepted that there was no place in countries such as in Roman Catholic Cameroon or Iran where a gay person could safely relocate. In RG Colombia, upon remittal after the 2006 Country Court of Appeal case, the Home Office identified a street or a couple of streets in Bogota where they had a few gay-friendly cafes and restaurants. We were able to, and that one street was the internal relocation alternative, and we were able to identify through a country expert report that showed the greatest prevalence of homophobic attacks. That point wasn't decided because RG had been in the country for many years and was able to benefit of what was called the legacy policy and got indefinite leave to remain. So that point wasn't yet determined. So we have to be very careful because the natural nuance is there is no availability. Now I'm looking at the time now. Yesterday, the Human Rights Commissioner provided her report in relation to various countries. And we can see, for example, in Honduras, the attacks on LGBTI. So that's why it's so important to keep up to date in relation to the country information. So Honduras in relation to state of facts. And even though we got completion day on the 31st of December, we can see even countries on our own doorstep. So Poland, in those relations to the LGBTI-free zones, is causing concern to the Human Rights Commissioner in relation to risk in those areas. We can also see Hungary. It's going to be very interesting to see how protection cases are decided post 31st of December, when we also can revisit, in my opinion, the issues in relation to European countries at no longer being the so-called safe countries. Now, part 4, we are going to overrun, and I'm going to try and do this in about 5 minutes, and you do have the slides, the conduct and return. And there are 2 issues which I want to look here. So paragraph 82 of HRL talks about, well, will they live openly? And if they don't, the question is why. Now, the voluntary discretion test, because they choose to live discreetly simply because of how they want to have. So the first part of the conduct limit regarding voluntary discretion in paragraph 82 takes away refugee status from the LGBTI individual by saying you have only shown that you'll be voluntarily discreet only because of personal or social pressures. And on that basis, we will deny you refugee status. But if you succeeded in establishing that wouldn't be the case, and that a material reason for your discretion is because of fear of persecution, you will get refugee status. Okay, so let's look. And Lord Walker also talks about the fact that you can have this fear of persecution as well as fear of going against family feelings. So there's a whole melting pot of reasons in relation to persecution. And Sir John Dyson, as a Master of Roles, also cross-refers back to the gay martyr issue at paragraph 123. So the Supreme Court provides this open approach in relation to look at how the gay martyr is treated and what would have to happen in order to evade persecution. So question 3, should discretion continue to be applied in protection claims? Please vote yes or no. Okay, let's have the results. 65% say no, 35% say yes. Okay, so let's get the screen and let's look at 2 elements I want to quickly look at. Question 1, what is the basis of being open in the UK? And question 2, how to prove straight on return? Now, the whole issue is that, well, the UK is such a free and loving society. As a lesbian gay person, I know with LC Albania, he had the issue that he'd just turned 18, had no ID because his previous representatives had not applied for the extension of his discretionary leave as a UCAS in time. And the first year tribunal in Newport says, well, you're not going to gay bars and clubs in Newport and getting a boyfriend. You know, how could he, he had no money, he had no status, but it was expected that he would go to gay bars and clubs and find a boyfriend. Well, let me look at 3 source documents in relation to that. We're looking at Chikwendo Numera, and I talked about the fact that look at academic articles in this. And she examines the position of Nigerian lesbians in the USA, and she talked about the double identity, the fact that when you're living within the diaspora, you have to deal with the homophobia within the diasporic community. We find a lot of diaspora communities whilst living in the UK are far more conservative than the communities back home. Yeah? And that's what Chikwembe looks at, the issues in relation to this double blind. I had a lesbian client from Uganda many years who hadn't claimed asylum for 16 years because she had to live on the down low within the Ugandan community without coming out as a lesbian. She found that intolerable in the end and broke free. But the one issue which was put against her is that you should have been open far more. What about racism within the LGBT plus community? We have the Stonewall report for June 2018, and it said 51% of BME LGBT plus people faced racism within the community. Yeah. So the evidence in relation to the statistics by our own NGOs say that even being out as a BME LGBT person has negative connotations. And then you have the Government Equality Office July 2018 report about the level of violence. We know about the level of homophobic and transphobic violence to people in the UK, whatever the colour of their skin. So we have to revisit this whole perception, this presumption that everybody will be open in the UK. Question 2, how to prove straight? Perception is key. And what I want, and I've got a section in relation to the EU Withdrawal Act. To summarise very quickly, nothing changes. After the 31st of December this year, on completion day, in relation to protection law, my view is quite clearly nothing changes because we have the relevant directive provisions within the international protection regulations or the immigration rules, and what isn't within the immigration rules or the international protection regulations we can rely on as a part of direct effect, see Marseille. Now, actual or imputed, focus on the view of the persecutor. Let's reframe the analysis and not specifically look at the victim, but why is there persecution? Without the persecutor, there is no persecution. And it's all about the non-conformity, the evidence of difference giving rise to persecution. As I said, not straight enough, the non-conformity. So we're looking back at Regulation 6 or Article 10.1. The group has a distinct identity because it's being perceived as different by surrounding society. Imputed the test, and this is where the focus really should be, 10.2 or 6.2 of the International Protection Regulations. Immaterial whether the applicant actually possesses the characteristic, provided it is attributed by the persecutor. Look at the political opinion cases, RT Zimbabwe, the fact that they weren't able to prove that they had allegiance to Mugabe because they couldn't sing the ZANU PF songs. Yeah? So that's what the issues are looking at. I'm looking at Gomez. There was a recent case which I did in relation to a Honduras criminal gang. The fact that you do not adhere to the rules of the gang gives rise to imputed political opinion. That was successful at first instance and not appeal. So it's about non-conformity. It's about 10.2. In 2005, in DW Jamaica, I raised that point with the AIT, as it then was, to say it's about perception is all. That was the first country guidance case in relation to Jamaican gay men and bisexual men. It's still in force since 2005. Because what I submitted to the AIT is that it's not about being gay or lesbian. It fits everybody who have encountered difficulties because of their actual or perceived sexuality, including trans people. These are the language at the moment. So everybody who does not conform, who does not fit in. In 2011, because of course, whilst gay men and bisexual men were protected, lesbians still lost in the tribunal cases. And we knew that this was just, how can this be? If gay men are persecuted, and this is the double blind in relation to cases of lesbians and bisexual women. If we find that the evidence really targets gay men and bisexual men, then how can lesbians and bisexual women also not be targeted? Because they have the added issue of sexual gender identity plus gender. Yeah, so especially in patriarchal societies, they're invisible. But in SW Jamaica, it's accepted that women have to be sexually receptive between the ages of 16 and 60. And if a potential persecutor has a sexual advance towards the individual and they're not receptive, and they cannot show evidence of a male partner, of children, or recent widowhood, then if they reject the sexual advances, there's a real risk of curative rape or murder. And that is the law in the UK. We accept that even straight women who are not sexually receptive will be imputed, will be perceived as lesbian, as sodomites, by the potential persecutor and at risk. Domestic violence, the case of DD. We're looking at DD again in the next session, so I'll come back to that then. There's a recent case of Iraq SMO, which also had, in paragraph 314, a reference to those not conforming to Islamic mores. In October this year, we have the case of YD Algeria, which will revisit the tribunal's approach in 2016 in OO Algeria. That's in relation to non-state agent persecution. What we do find, I'm going to hopefully highlight this to you, is that whilst OO was focusing purely on non-state agent persecution, we can see from the US State Department report clear evidence in the past 3 years of state persecution. So there's no internal relocation alternative. Physical sexual violence by the police and authorities towards the LGBT community. And there was even the murder of a medical student, a bisexual medical student in Algiers last year, and Algiers was supposed to be the safe internal relocation alternative, so that's evidence on the other. The most recent case, of course, in relation to perception is DH, Afghanistan. And you have the paragraph in the head note there. The key issue is how the individual is viewed in the eyes of the potential persecutor. That's a disability claim. Then you have the silence fallacy in LC Albania. Because it's quite interesting. We were in the Court of Appeal, my juniors, Jessica Smeaton, the instructor solicitors, Vanessa Delgado. And on the same day, we were in the Court of Appeal. There was the litigation against the plainclothes policeman who had infiltrated the animal rights activist groups. And the women were quite rightly saying, look, these men duped us in believing that they were fellow activists. And the emotional and physical relationships we had amounts to sexual assault and rape. And what this was saying, this is what happens in these countries. To be able to evade identification, the LGBT person has to take the form of the straight person. And not only the LGBT person, but the person they have to prove their straightness is also affected and also a victim. So the Court of Appeal Law Justice Higginbotham says we have to base it on the evidence. So they weren't closing the door. They're saying, look at each country and says, what is the evidence the gay person would have to engage in order as not being perceived as gay. And you see LH and IP in one of the non-offending paragraphs, which I think is important. There's a lot of Australian case law in relation to Bangladesh, is that forced marriage in effect amounts to persecution. And this is what happens with a lot of heteronormative countries. Well, I mean, there's no gay country. Lesbos is not a gay country. In a lot of these countries, individuals will have to be forced to marry, especially if they come to a certain age. Why aren't you married? And we talk about that in the SW Jamaica and the politics of gossip. Another important case, and I'm going to finish with this before having very short questions and answers, is MA Pakistan, because in that case, the individual had paranoid schizophrenia. And the upper tribunal quite clearly accepted. We're not looking at open or voluntary discrete. That individual could not control whether he's open or voluntary discrete because of his mental illness, his paranoid schizophrenia. So in that case, we also have another limit. It's not just open and voluntary discrete, but inability to be able to control conduct, involuntary conduct. And that's a case of 2019, and the individual's now a refugee. So here's a question by Susan Benedier from Sentinel Solicitors, who asks, country expert reports, what expert evidence would you recommend us for gathering these types of appeals? Country expert reports where the Secretary of State's COI is being challenged or ambiguous, and medical psych evidence in relation to past persecution, but not in relation to proving straight. Okay, so I'm going to stop sharing screen, and I'm going to ask AXA. Hi AXA, do we have time for a few questions? And I can see that we're overrunning, but do we have any questions?
Yes. So, Chelvan, at the beginning, you mentioned this concept of the emotional journey, and that some of the elements were the physical element, the emotional element of the journey. Is there a spectrum by which governments consider one or the other to be more important when looking at evidence for those seeking asylum?
Well, I think the important thing is that it's all about the narrative, and that's what we're looking at in session 2 about the DISH model. It's all about giving that space to the individual refugee applicant to be able to sit down and tell their story. Because we know from Article 1A2 that it is an emotional as well as physical journey, because the individual, whilst the individual does not need to show subjective fear to be a refugee, because we wouldn't send Anne Frank back to Nazi-occupied Germany if she hadn't been incarcerated in the attic, is that we have to show the issues in relation to future risk and future fear. So that's why I think it's very important. I'm looking at the time, and maybe we can import some of the questions into the next session. So thank you. We're going to have a quick 15-minute break, and I apologise that we're overrunning slightly. There's going to be some slides created by the amazing Jonathan Lee, as well as halfway through there's going to be 3 DISH model video testimonials by Vanessa Delgado, consultant immigration solicitor, Michael Ferguson, who's a solicitor, and Adronke Apata, a human rights activist, who are going to be talking about and sharing their experience with the DISH model. So thank you very much, and look forward to seeing you after 15 minutes for session 2. Thank you.
Hi, my name is Vanessa Delgado. I'm a consultant immigration solicitor with Duncan Lewis Solicitors. For me, the DISH model is a really important and useful tool for when I have clients with sexual identity-based asylum claims. It's especially valuable when there is an alleged lack of credibility, which is a common reason for the Home Office to refuse an LGBT claim. There's also other examples. So, for example, if delay in disclosure of one's sexual identity, or where someone has, for example, had to adopt a heterosexual narrative in their country of origin in order to avoid risk. The DISH model also highlights what the Home Office often forgets, that sexual orientation is an expression of identity and not just not just about sexual conduct. It helps the Home Office, the tribunal, and lawyers understand that discussing discovering one's sexual identity is often a complex and gradual process. And lastly, I think also what's really important about and useful about the DISH model is that it gives you guidance and as to what needs to be included in a witness statement, so as to elicit a detailed narrative that will then be provide vital evidence to help clients establish their asylum claims.
Hi, my name's Michael Ferguson. I'm an immigration solicitor for two different homeless charities. One of the main problems I find with LGBT asylum claims is obviously credibility. The Home Office basically just refuse to believe that someone is gay or lesbian, which is obviously a major problem in proving your case. No matter how much corroborative evidence you're able to produce, many claims still come down to credibility. The DISH model has helped me enormously following my contacts with Chelvan, principally in giving a framework to produce witness statements for my clients. Different stigma, shame, harm gives just a brilliant format and a brilliant way of thinking about a person's life experiences and placing it in a structure that is appropriate. And it's also useful for other witnesses and for trying to gather corroborative evidence along the same themes. So overall, I have found the DISH model enormously helpful in a number of my cases. Thank you.
My name is Aderunke Apata. I'm a human rights activist, feminist, and LGBT equality advocate. I also have a BSc in microbiology, a Master of Public Health, a graduate diploma in law, and currently studying the paraprofessional training course and Master of Laws. As a person who got granted asylum after 13 years of battle in the UK, in 2017, that was when I was granted. I know that the greatest hurdles for the LGBT plus applicants seeking asylum in the UK include the Home Office's culture of disbelief, its high standard of proof in relation to sexuality policy. They assess sexual activities and not sexual orientation or gender identity. There is also the lack of access to justice for LGBT people seeking asylum due to court in legal aid. Some legal team even go as far as dumping some of the LGBT plus people seeking asylum clients at the last minute. Their excuse is that their cases do not merit the threshold. These legal teams turn themselves into judges instead of advocates. I happen to use the DISH model. The DISH model helped me to put my case, my fresh claim, across in a better way by exploring what makes me different, which is my sexual orientation as a lesbian, the stigma associated with my sexual orientation, the shame that I experienced back in my country due to my difference and the stigma, and then the harm that I was exposed to back in my country, Nigeria, and what I would be exposed to if I was returned back to Nigeria. I was very, very lucky to have Dr S Chelvan as my barrister. African Rainbow Family today adopts the DISH model for its members. And we have record number of success in the people being granted asylum, because we've been able to use this DISH model to prepare the cases in exploring the difference, the stigma, the shame, and the harm. I recommend this DISH model to anyone who is preparing to assist anyone seeking asylum based on their sexual orientation or gender identity. Thank you.
Right. Well, welcome back to the Migrant Law Clinic, episode 2, the emotional journey in the DISH model, and session 2. Becky's going to kindly put the link to the second set of PDF, the PDF document, in the chat room. Whilst she's done that and you're downloading the documents from the web page, I think the testimonials are so important, being able to provide an insight in relation to not only how immigration solicitors such as Vanessa Delgado and Michael Ferguson are using the model in relation to the cases they work on, but also seeing the direct impact to Dronke, and we'll be talking about her in a few moments. The fact that she was disbelieved for so many years, and she was not only failed by certain decision makers, not only the Home Office but the courts and the tribunals, but also by legal aid lawyers who told her she had no chance and no avenue, and it was through her strength and her courage that she was able to empower herself to be able to in a position to then move forward and now be a refugee. I'm just going to share the screen. Okay, great. So we're looking at session 2 and the DISH model. I have been asked in the intermission, please don't feel shy in asking questions and answers into the question and answer box at the bottom of your screen. And also I will make sure that you've got more time in relation to answering the survey questions. So therefore, I know a lot of people wanted to contribute, but the box had gone off the screen. So I apologise for that. It is going to get on the screen for a little bit longer. Let's talk about vision. I recently did a course this summer, the Executive Leadership Programme at the Side Business School. And we talk about vision, and we talk about shared vision in relation to what all of us, whatever starting point we're on, the person seeking asylum, the Home Office presenting officer, the judge in the tribunal, what we all should be doing in relation to that is to ensure that those who are in genuine need of protection get asylum. So my vision statement, in effect, for us to hopefully share today is to ensure any individual who has a well-founded fear of persecution is provided sanctuary in the United Kingdom. And so this is a Dronke Parta outside my chambers in August 2017. After 13 years, the Home Office granted her asylum after being in the UK. And to give you a short summary, Dawson and Gerber, two academics in Australia, published an article in 2016 and used Dronke's position as one of the 5 case examples of why the DISH model doesn't work for lesbians and bisexual women. And I remember when she got her negative decision by the High Court in the spring of 2015, going to a meeting at the Home Office where the colleague in the Home Office is brandishing the High Court judgment. And I said, look, I've got to leave the room because I'm now instructed as counsel. But before I left the room, saying, look, this is how we prove false claims. And her position was that she'd had children in Nigeria, therefore she couldn't be a lesbian, or she changed her physical appearance and expression, so therefore is all a public performance. And the problem with the Dawson Gerber article was that none of the case examples showed any evidence of where the DISH model had been used in relation to the narrative. And most importantly, as we know, with Dronke, and she shared this with us today, is that when her fresh claim was submitted in August 2006, which was unfortunately after the publication of the article, the DISH model was used. It gave her the ability to be able to tell her narrative. Because I always believe that I have 2 roles. I'm a storyteller and I'm an interpreter. And the reason why I'm a storyteller is I tell my clients stories. And then as an interpreter, I interpret their stories into what we call the foreign language of the law. But to be able to tell their stories and to interpret into this foreign language of the law, the individual person seeking asylum must be able to tell their story. And as the quote, my favorite quote from Francis Bacon and Thomas Hobbes, knowledge is power. We do know, and we are on the same page here, because none of us here would be doing this sort of work if the UK did not grant asylum to refugees. And we want to be able to find solutions for those who are genuinely need in protection. As I said in the first section, there's an alphabet soup of different identities. And I want to make it simple because it's not about those individual identities. It's not about straight enough. Now, this is a rather interesting footnote in the skeleton argument of H.T. Cameroon in 2010. And I've amended the word for obvious reasons. But they said the word gay is preferred to the word homosexual for much the same reasons the word black is preferred to the word N-word for a descriptive purpose for a particular sexual orientation as for a particular race or ethnicity. On the day the 2006 judgment from the Court of Appeal was handed down in Jane, the first Morris case, I was at a training session of immigration judges in Taylor House. And I remember, I'm not going to name the judge saying at one point, for some reason he didn't know that I was gay, but he said, why do they have to use the word gay when it means so many different reasons? Why do they have to take the word for themselves? And the analogy is just like, it's all about self-empowerment and the liberation movement. It's about words of empowerment, not words of hate. And the term homosexual has got such a bad history in relation to discrimination and persecution. So it's all, for me, I have clients, the first question I ask them after the whole point is, how do you self-identify? It's for not me to impose an identity on an individual, it's for the individual to be able to express their identity, whatever it is. And in nearly 20 years of practicing specifically in this field, I have had individuals who have used the word homosexual, and I've respected their right to do so. So it's about self-identity expression. As I said, not straight enough, not cis or straight enough. As we know, we have the history, and we always think the Refugee Convention is embedded in relation to the 51 Convention. Here we have a photograph in one of the Nazi labour camps, the pink triangle for gay men, for lesbians, it was a black triangle for bisexuals, it was a purple. It was their badge of different stigma, shame and harm. But there is a historical context, even before the 51 Refugee Convention. In October 1933, you have Belgium, Bulgaria, Egypt, Norway and France coming together due to the influx of refugees from Russia and the Azeri population, coming together saying we need to protect. That was then adopted by the League of Nations. So there is a prehistory, but this is the first time that countries come together in 1933. And as we looked at the definition of Refugee Convention, well-founded fear outside the country of nationality, we have these journeys, both physical and emotional. Let's get to the basics here. Being human is about emotions. It's about that emotional journey. The quote I love is that life is a journey, not a destination. Yeah. And what would life be without emotions? As I think I mentioned about him in the first session, Dr Sentharan Raj, a very good friend of mine, fellow Sri Lankan Tamil queer activist, and I use activist in very much the positive sense. I think it has a very positive sense as well. Does a lot of work on emotions and the law, so I'd really recommend reading his work. So as we said earlier on, the physical and the emotional. Because there's no on-off switch. You don't switch on and say, one day I'm gay, one day I'm straight, well, bisexual. It's not something which happens in that sort of flick of a switch. So let's try an exercise here, and some of you will be familiar with some of the photographs here. This is all the issue of a learning side. So can I prove that I am gay? Clearly I'm in somebody else's home, not my own home, but that shouldn't be able to identify I'm gay. So can I prove that I'm gay? Well, this is a photograph of my husband and I, taken in 2011. The dogs are actually in the lounge. I sort of tried to bend the arm of my husband to come in and make a cameo performance. I don't know if he will do. But anyway, so that's Mark and I. We met 19 years ago in October. In 2011 in Soho. Those are two dogs. On the left is Nomos, the black and tan one. They're 10.5 now. On the right is Veritas. So Nomos is Greek for conventional rules, and Veritas is Latin for truth. I did my undergrad at Southampton. There's a politics bureau called Nomos, and Veritas, of course, is the logo for Harvard, where I did my master's. So that's them recently for the Lally Awards with a crown Crown. The Crown's just around the corner in the hallway. And as you can see, they're amazingly gorgeous dogs. They have amazing personalities. That's us in middle of London in 2011 for Gay Pride. An interesting photograph that, of course, was because that morning we were at Gay Pride, and the afternoon I had to fly off to Uganda because I was at the ISM conference talking about LGBT asylum in Uganda. As you can imagine, slightly a worrying experience to have to talk about LGBT, anything LGBT in Uganda at the time after the introduction of the 2009 anti-homosexuality bill. But that's how life is. That's us again. We call the dogs our pre-kids because they're preparing us for children, hopefully one day. Taking photographs. That's the first time out of the Supreme Court. That's us in Ibiza for my 40th, drinking exotically coloured cocktails and clearly listening to Kylie. That's us at the second marriage. We had 2 weddings. We had a civil partnership in 2006, and that's our conversion, horrible term, whoever dropped that, a conversion to marriage in June 2015 at the Inner Temple, where I am a member since 1997. That's us in Maui. Yes, no, not Maui, Key West. Maui was honeymoon number 1, Key West is honeymoon number 2. That's us outside Buckingham Palace for a reception. That's us having a Christmas tree at the Chapel Market. That's just a couple of weeks ago outside the Piccadilly Circus Lights, UK Black Pride. I'm the international rights officer there, having our images for the 15th anniversary. Amazing event. I never thought I'd have my photograph on the Piccadilly Circus Lights. And then that's us at a restaurant nearby in King's Cross, my birthday on the 1st of September. And that's us at the Everyman Cinema the other week, seeing Les Miserables, great film about Paris. So have I proven that I'm gay? That is the question. By just showing you a few photographs, giving the narrative, should that not be enough? Now, these are examples of how not to prove queer. Now, philometry and vaginal photosomography. One day I'm going to be able to pronounce those words. I hope I don't have to repeat them many times. And what we know is that in 2008, not the Slovak authorities, but actually a lawyer in Slovakia representing a gay man from Iran whose credibility was shot to pieces. In Eastern Europe, they have people called sexologists. And these sexologists, she went to the sexologist and said, look, how do I prove that my client is gay? Oran did a very probing report in 2010 in relation to these sort of apparatus. And you can see the apparatus is actually, that's the apparatus on the top, which is inserted on the penis, on the male genitals, and around the main genitals. You see that in the bottom. And then you see the bottom picture, that is the apparatus which is inserted into the vagina. And what happens is those apparatus are inserted in the vagina or on the penis, and then pornographic material is then shown to the individual to see what their sexual response is. And clearly, if their sexual response is negative towards gay porn, then clearly they haven't proved gay, etc., etc. Now, I mean, the point is, not that I'm sharing anything, but I don't know how many people would be able to have any reaction, especially sexual reaction, to any sort of pornographic material when you have apparatus like that around you. Now, we know that was happening in the Slovak Republic, even as recently as 2011, when I was there in Prague giving training in 2011. UNHCR had heard a report there. The German Administrative Court in 2009 actually halted a Dublin removal from journey to the Czech Republic because of the use of this sort of procedures in the Czech and Slovak procedures. They said it was an infringement of Article 3. Here we have an individual taking photographs as a pornographic movie is occurring. Let me share an experience. This was a sort of discussion on the refugee legal group in December 2012, where an individual at that time, because remember, what happened was we have 8J Iran in July 2010 saying it's a discretion test, apart from this minor recital in relation to only being discreet because of personal social change, that the discretion test is really gone. So having refused 98 to 99% of cases on the reasonable tolerability discretion test, now what was happening is, well, prove that you're gay. So having initially accepted on one set of processes we're not privy to, saying that we accept you're a bisexual woman from Egypt, now all these individuals were having to prove that they were LGB. And I remember being at a meeting where an individual from one of the member states, there was an intergovernment meeting in Switzerland, where the individual, I won't name all the countries, said, well, I know what straight is. and then realised after a nanosecond that I was in the room, it really wasn't a thing to say. So in this exchange, the individual is asking about the fact of a video in relation to him having sex with his partner, proving that he's gay. According to the person asking the question, it's very convincing to prove that the individual is gay. It's all based on sexual conduct in relation to a sex video. Now, the reply, this is from a solicitor in the Midlands who replied to this and said, well, we had a similar case. We had an immigration judge in Bradford, and the immigration judge gave us permission at the case management review to submit that material. We submitted the video to the Home Office, and you see that last line. Surprisingly, the presenting officer's unit assessed before the full hearing that the client was not aroused. So because the one can only imagine the sex acts or what was going on, but because the individual person was not aroused through the sexual acts, and clearly they weren't gay. This is what solicitors, legal representatives were doing on instructions from their client, because they said, look, we've got instructions of this, we should not feel embarrassed. But in my view, this was a clear issue of professional conduct. I was hearing these stories when I was giving the Stonewall lecture in 2013, thinking, what is going on? What sort of society are we that we're telling a drunk even submitted a video with her and her girlfriend in 2014 March to try and prove that she's a lesbian. I try and insert some humour here because, the joke when I was an undergraduate is, what's the difference between a straight man and a gay man? 2 pints of lager. Yeah, and that is, trying to be slightly cynical, but we're just talking about sexual acts. We're not talking about identity, and that's why I think it's very important to be very clear. And even submitting that material is a clear infringement of a violation of degrading treatment, Article 3 violation of the UCHR, for that sort of procedures to happen. This was an interview of a Jamaican bisexual client who was asked by the presenting officer, and this was the famous interview which then led to the review by John Vine in March 2014 following Theresa May as a then Home Secretary's request for him to look at that, is that what do you find attractive about a man's backside? Sorry, apologise for the typo there. Did you ejaculate at him? Why did you wear a condom? These are questions asked by that individual immigration officer the interviewing officer in Hasler in October 2013. So let's ask this question: can sexual conduct be relevant consideration in asylum claims? So let's take some time for you to respond. Okay, let's see what the results are. Can sexual conduct be relevant? Okay, 71% say yes and 29% no. Okay, so let's proceed in relation to look at the analysis. As I said, there's no on-off button in relation to choose to be gay, yes or no. And what I want to be able to stress is it's the issue of not living a heterosexual narrative. Society is programmed to tell individuals that you will lead this life. You speak to LGBT people, you're expected that it is changing in certain sectors when they're far more liberal households, but in the majority of households, children are being told you will marry, you will have children. It's an expectation which is sometimes not damaging. It's just an expectation of how we believe society is. We have unconscious bias. We expect people to behave in a certain way. So let's look at the photograph. So as I said, I'm going to share some photographs. That's a photograph taken in January 1983. Now, it's in Burgess Hill. You can see my maternal grandmother in the back. She was born in Ipoh in Malaysia. We're in Sussex, and it is my younger brother's 7th birthday. He's the little boy in the blue jumper. This picture's quite interesting for two reasons. First, it's the only photograph where you have one of two photographs where you see my back away from the camera. This is the other one. This is me walking down the tour at the beginning of the opening ceremony of the London 2012 Olympics. I just thought I'd share that with you. But back to my brother's birthday. This is my brother. He is actually a consultant neurosurgeon. That is actually him operating on a brain. He used it as his Twitter. He's my little brother, so I'm labelling him with that for life. And that's him a couple of weeks ago. He lives in Wylam near Northumberland. That's his wife and 2 kids. It's the first time when the lockdown regulations were eased a bit, having lunch with a family. That's on his Twitter account as well. Now, this is going back to my brother's 7th birthday. Can you see the birthday cake? Yeah, that's 7th birthday cake. My mother made it. It's a football field. So it's a real boy's boy. It's what you expect a boy to be. Loves football. Yeah. So this is my 7th birthday. We're going before a bit. So now in September 1981. I see with a few of my friends there with the birthday cake. Can you see the birthday cake? It's a number 7. It's made with green pistachio icing with pink roses. Yeah, I was 7 years old. You can see the little badge there. What I wanted was a number 7 with pale green with pink roses. This is my brother's 9th birthday. This is January 1985. We're now living in Worthing, Costa Geriatrica, as it's commonly known. You see the birthday cake? Star Wars figure, R2-D2. Yeah, so you can see that. Real boy's boy wants R2-D2. This is me back in Burgess Hall for my 9th birthday, September 1983. This is my father now passed away, saying, "Look, Chelvan, you know, you've invited all these people. Most of them are girls. I remember my brother going to the front door saying, 'Look, another girl.' But I'm just friends with girls. You know, we just sit around talking about boys, making daisy chains. You know, I just connected more with girls than I did with boys. This is my father's family. He was the eldest of 9. You can see him in the tie in the back. You know, good old Ceylon in the 1950s. That's how families were expected to be, large and with many children. So going back to my 7th birthday, you see the birthday cake, pale blue. You know, lots of girls at my birthday, pale blue marzipan with roses and butterflies. Now, did I know that I was gay at the age of 7 or 9? Clearly I didn't, yeah? But I knew I was different. At no time did I think that I was a girl in a boy's body. That's gender identity. But I knew I didn't quite fit in where other boys fitted in. Now, I just wanted to go back a slide, okay? So I went through these slides and I showed you also the slides of my husband and I. I only show you one slide of my brother with his wife and his kids. Now, I'm not going to do a poll at this stage, but think about how I just went through one slide. I said, this is my brother, wife and kids. Did any of you question whether he's proved his sexual identity? Did we all assume by this picture, and just by saying the narrative, wife and 2 kids, that must be his wife and 2 kids? Could it not be a friend with her children? Why are we not questioning, saying, well, that doesn't prove his sexual identity as a straight person? I mean, I can tell you quite clearly that he's straight, not gay, or bisexual. But the point being here is that we very much assume, it's our unconscious bias, that when we see something we expect, then we're very quick to assume. When we see things which we don't expect, which aren't the norm for us, then that leads to questioning and doubt. Now, with all my clients, it's about creating a safe space, ensuring that that space is created to ensure that they can tell their story. The first thing I say to my clients when I meet them is, look, I introduce myself and say, look, this is a safe space. I say those words. This is a safe space. Nothing will happen to you. No one will harm you. No one will take you and entertain you. This is a safe space. And you see their shoulders go down in sort of relaxation, because they're so stressed, they're stressed with it. Everything else is just relaxing. And I say, look, this is your time to speak and my time to listen. Because we're so ready to ask questions all the time. And one of the most important bits with advocacy and everything is not the ability to speak, but the ability to listen. Yeah, so let's talk about the Dish model. Coming to the Dish model now. So the credibility, Credo did this project with the Hungarian Helsinki Committee. This was volume 1 in 2013. And 2015, when you go to your PDFs, you can double click on the image and go to the report on RefWorld. This is the volume 2 of RefWorld in May 2015. So what is sexual orientation and gender identity? This is the original Georgia Carter Principles in 2006. And it says sexual orientation, understood to each person's capacity for profound emotional, affectional, and sexual attraction. It's not just sex. It's about what Shakespeare wrote, about being in love, the emotions and the affections. And importantly with gender identity, it is important to be able to understand it's not just, it is not dependent on modification of the bodily appearance, function, or medical, surgical, or other means. So it's very important not to say, well, you can't self-identify in a gender which you weren't ascribed at birth, what we call the biological natal or cis. Natal identity, which is the cisgender. You can identify. I have a client at the moment who very much says that, I am a boy who happens to be trans. Yeah, that's really, really important to be able to give the words, the ownership to the individual rather than force. So in chapter 11 of that manual, we have the references to the sexual orientation, gender identity, and the Dish model. So we're looking at stereotypes. We are so easy, as I said, unconscious bias. What we expect is gay and what we expect is not gay. Look at the second image, footballer not gay. Yesterday we had the bisexual rugby player, I think it was Bath, who came out as bisexual, who had earlier come out to his teammates as bi a couple months beforehand in April. So we're all about challenging stereotypes, that we can all be different. In December 2014, the Court of Justice gave the judgment in ABC, which is a judgment that's very important because we're saying we're not here to assess purely on stereotypes. I remember reading determinations from years back which says issues such as they weren't feminine enough or they were too quiet to be gay. Yeah, no questioning on sexual practices alone. That's really important. It's not just, as I said, 2 pints of limit. Gay, straight, yeah? Sorry, straight to gay. So it's all about ensuring that we focus on the identity. No use of evidence showing sexual activities. I mean, that is degrading, let alone not exactly probative, because if we're a society which has evidence like that filed, then clearly we're doing something wrong, and there are no tests in relation to that. So, question which I usually ask when we're not in the Zoom platform, when there are human beings in the room, is that I ask somebody to volunteer who self-identifies as straight and male. I said, when did you first realise you were straight? And the majority of times, because usually there are some straight men who are clearly in tune with their sexual identities and have been thinking about this for many years, even when they were children. But the majority of straight men say, well, I don't know. And the point is, well, what's our response to that? Do we say, well, you haven't proven that you're straight. You should have known when you were straight. Why didn't you know you were straight? And it's all to do with that conditioning, which we were referring to a few moments ago, is that a lot of straight men, predominantly straight men, never question their sexual identity because this is how they've been programmed. This is how they've been brought up. This is who you are and who you are expected to be. So let's start off with difference. So in the Credo Manual, we talk about difference, is that we do grow up in heteronormative societies, that anyone who is not straight will start with a journey in realising that they are different. Now, this is Kirsty, who's reported in the Stonewall Report in 2012, and I've emphasised certain passages within that report. I knew I was different even in primary school. And she talks about the stigma she feels, and we'll talk about stigma in a few moments, from the friends and parents because of fear of disclosure. Yeah. The Court of Justice in November 2013, in a case called XYZ, going back to the definition of particular social group, ruled against merely unenforced criminal legislation against LGBTs being enough to amount to persecution. But importantly, when we look at the definition of particular social group, accepted that the notion of identification of different to surrounding society establishes the particular social group. That's paragraph 45 of XYZ. More recently, Advocate General Wall in October 2017 made it quite clear that it's more than that. It's a perception of to be non-gender conform. Yeah, and that's really important, paragraph 30 of his opinion. That wasn't distinguished when it came to the court's opinion, but that's a very, court's judgment, but it's a very important aspect of the opinion. And if you look at paragraphs footnotes 15 and 16, those are quite important issues. Even going to a gay pride, you could be perceived to be gay in certain countries. So that's very important. Now, we're talking about trigger questions. Yeah? I remember going to a Geneva conference in June 2011, just after I started shaping up the DISH model. UNHCR was holding that conference with NGOs. And somebody from UNHCR, someone from Aurum, was saying, look, we need a questionnaire. We need 40 questions which will prove that somebody is gay. Now, being the shy, retiring, wallflower type I am, as you can imagine, I stood up and said, absolutely no, well, I didn't stand up, but my voice carried in the chamber and said, absolutely no way. Because we know what happens. Those of us who have practiced in the area for many years can give the example of Somali minority clans. Yeah, the individual will say that I'm a minority Benadiri, and they'd be asked 40 questions. And they only get 15 out of the 40 questions correct. You're not minority clan. They get 39 out of the 40 questions correct. You're not minority clan because you've learnt the answers from the internet. Yeah, so it's absolutely no use having a prescriptive list of certain questions to prove queer. What we do is provide trigger questions to be able to explore with the individual person seeking asylum so they'll be able to tell their narrative. So with respect to application of difference, look at those examples. They're non-exhaustive lists in relation to that, not like other boys or girls. Gradual recognition of gender difference. Sometimes experience the same sorts of conduct. Persecution can be so rife that the individual doesn't feel that they're in a free space to be able to openly express their sexual or gender identity. But personal experience of living differently. Now, importantly, political scientists make this quite clear, is that when you're an individual and you see other people who are like you, and then you attain your membership of that group, we call that group differentiated identification. Yeah, and this is usually a positive experience, not a negative experience. And importantly, within the DISH model, it's not where the emotional journey starts. Difference is not where the emotional journey starts. Difference is an identification of the difference. So you look at the most recent Home Office Asylum Policy Instruction and Sexual Orientation. This is August 2016. And you have within the policy document recognition of the issue of difference within that. Recognition that the claimant is not like other boys. So it follows off from the DISH model, which was adopted by the Home Office since 2015. This is an example from LGBT Voices around from the Arab World Unit HCR in 2018. And this is Ellie from Lebanon. Lebanon did have quite a thriving gay scene, and we know what's happened recently with the destruction there. I did an unreported case on Lebanon, and they had actual anal testing by police forces, and my client got refugee status. But Ellie says, when I was very young, I knew that things were different for me. Yeah. This in last week, Alison Bailey, a member of the LGBT Alliance, put out a post saying a 12-year-old is a child, stop putting children with adults and labelling it LGBTQ. There's a huge drive to say that trans kids can't be trans, that they're being forced to be trans and take a certain course in relation to their lives, rather than what they are is lesbian or gay and being forced into a gender identity. And not only Stonewall, but other people took on board and saying, well, look, when did you realise you were LGBT? And this is one example. There were hundreds of others. Scott Cuthbertson, who's an activist in Scotland, saying, I remember thinking there was something different in primary school, aged 10 to 11. So when you start the narrative on when did you realise you're gay, but when did you realise you were different? It's usually a light bulb moment for people seeking asylum on sexual gender identity, because they don't really get asked that question. I still see interview records. I've recently been instructing a case in Glasgow to write an expert report in relation to the use of the DISH model in an interview in the case, where the first question is, when did you realise you were gay? Or when did you realise you were lesbian? Yeah. So we need to go back to the narrative in relation to, sometimes, I'm not saying all, it's a positive tool, it's not a determinant tool, in relation to experiences of difference in childhood, in teenage, in young adulthood. It's about the experience of difference, because that is at the core of a refugee claim, whatever convention reason, because you only suffer persecution by the potential persecutor because of your difference, of your non-conformity of what is expected. Then let's look at stigma. Stigma, of course, comes from the Greek. What happened with the Greek ancient society? They get a hot brand in relation to people who are outcasts. Being gay was not an issue. We won't go into the historical context there. Put a hot iron brand on the individual, mark them to show that they were an outcast. Now, this is where the emotional journey does start with the DISH model. It starts with the fact of when you realise you're different, and then you realise your surrounding society, because you need to focus on difference and not identity here. So you have the three different Hungarian cartoonists who drew the cartoons, which are included in Credo Manual 2. So you have the priests in the pulpits in Adam and Eve rather than Adam and Steve. Yeah, you have what we refer to the politics of gossip in SW Jamaica. Why has she got why is she living by herself, or living with this woman? She's not her sister. Why are men not visiting the home? And then, of course, the stereotype, the Oscar Wilde with the pink triangle reference there. It's quite funny because we see this in case law even outside the refugee context. So this is Justice Scalia, who's no longer with us, in Lawrence, Texas, which was a seminal case which struck down the anti-sodomy laws in the United States following the earlier decision of Bowers and Hardwick in 1986. And Justice Scalia, in dissenting from the majority, said preserving the traditional institution of marriage is just a kinder way of describing the state's moral disapproval of same-sex couples. He was defining stigma. Yeah. Interesting enough, that paragraph was used in all the litigation subsequent to that to argue for same-sex marriage. So what happened when that point was put to the Supreme Court in June 2015 in Obergefell and Hodges is that Obergefell couldn't get the rights to pension rights for because he wasn't married to his partner. By statute, Obergefell and Arthur must remain strangers even in death. A state-imposed separation Obergefell deems hurtful for the rest of his time. So that's the stigma shame. We have the causal connection. Yeah, this is Rashid from Jordan talking about stigma. Walking down the street, people would laugh at me. Yeah, they identify the difference. Just as we said with Bembassi in the Turkish Cypriot case in 1989, he said, look, I go out on the street, we mix with my friends, and people would call me queer. Yeah, it's the identification of non-conformity. Now, it's interesting that Will Young recently published his autobiography, and he very much concentrates, I mean, not all of us are clearly like Will Young, but he concentrates on the issues of stigma and shame. And shame is where there is the internalized reaction, yeah? Not to the psychiatric level in all cases, but the normal reaction. That's what human beings do. When you're told who you are is wrong, then you have the impact of shame. So the dish model goes and investigates, well, how did you feel about that? You know, we're not yet talking about persecution. We're talking about the stigma and the causal connection between stigma and shame because of the individual's difference. Yeah, something wrong which needs to be changed or hidden. It's by the family, the community, the neighbours, society in general. Yeah, personified and stigmatized as someone different. We go back to the core issue, the issue of difference, hiding in that closet, not able to be who you really are. Chris Morris, one of the litigants in the Equal Age of Consent, talks about nobody should have to soul search and wonder why their love is considered less worthwhile than other people's. Nobody should have to question if loving someone makes them sick or evil, and nobody should be afraid to love, unable to even imagine themselves in love. Once again, Home Office API, stigmatization, shame and secrecy, looking at the continuum in relation to the family, to the larger bubble, to society in general. This is another extract from the UN videos, I felt like a freak of nature. Yeah, that's the impact of shame. So different stigma shame comes in the narratives of the majority of LGBT people the world over. You've just taken an example of that. What makes the LGBT plus, the queer refugee, the issue of harm? The harm which would be focused on them because of their difference, okay? The fear of suffering harm because of their sexual orientation or gender identity. That's a past narrative and the future risk narrative in relation to their identities. So here is a list of the various state and non-state agent issues in relation to that, which is very wide-ranging. So, as we know with refugee convention analysis, there's a lot of intersections. Yeah, so we can have gender-based harm, which is also sexual identity-based harm. We can have political opinions. So you go onto the gay rights march, and then you will be, targeted by the mob. Yeah, so we have a lot of intersection with convention reasons, which I find very, very interesting. It's important not to just concentrate on one convention reason and see the whole toolkit in relation to various. So you have, as we know, nearly 70 countries still criminalise same-sex, consensual same-sex conduct, and over 40 specifically in relation to lesbians. And we have, luckily Sudan has changed their penal code, so now we have 6 or 7 countries which actually impose the death penalty, including Mauritania, Iran, South Yemen, and Saudi Arabia, and parts of Somalia and Nigeria as well. So here we have the flow: difference, stigma, shame, and harm. So let's try on question 2. Is difference a positive or negative emotional experience? Please answer. Okay, if we can have the results. Wow, 50% think that is negative. Okay, 36 neutral, 8% positive. Okay, well, let's move on and explore that. That's very interesting. Okay, now the point being here is that when we look at the emotional journey, by starting on difference, that's where the error lies. So, for example, like I said, we've got our friend from Swedish Migration Agency here today. In 2013, I was asked to go there and give some training on the DISH model. In 2017, November, I was to revisit because they had some, they requested some further training in relation to that. And I was told by some of the delegates there's something called the Juncker law, where being different is negative because you want to be Swedish, you don't want to be anything else, just like the French issues of secular society. And therefore, when the individual person seeking asylum didn't show difference as being something negative, then they were disbelieved as engaging with the DISH model. May I make it very clear? Yeah? And it's also included in the UNHCR IOM updated training in 2016, and I have a huge problem with this, is that when it comes to issues, it's not the difference which is negative, because when you realise that there are other people like you, then that is usually a positive, because it gives you some sense of relief. It is the stigma, shame and harm which is negative. That's where the emotional journey really starts, rather than difference. Difference is an identification. The journey, which comes within the Refugee Convention subjective fear, happens when there's a reaction to your difference. So many societies, you have various groups which are different from the majority, but they do not suffer discrimination or persecution. So it's about that difference giving rise to persecution. So that's why the arrow starts with stigma, shame, harm, rather than difference. So from my viewpoint, of course, all of us can have various viewpoints, but from my viewpoint in relation to the DISH model, the actual difference should definitely not be negative. It can be neutral. But for me, within the majority of narratives, it's that recognition and relief of realizing that there are several other people like you, especially other people like you, because when it comes down to, as we said earlier, one of the questions is sexual conduct never to be included? Of course it's to be included. That's the reason, usually, and I hope this is shared by the majority of us, sex is a positive thing. It's a wonderful thing. Let's get the memo out. Sex is great. It's what happens afterwards and the reaction to other people towards that sex, as long as it's consensual, is where the issues arise. Yeah. So that's my analysis in relation to that issue. Now, we had a question from Dr. Jean-Pierre Garcia. Jean-Pierre was actually a fellow PhD student of mine at King, so hi to Jean-Pierre, who does a lot of work in trafficking. To what extent do you think the model similar to the DISH model can be applied to other vulnerable groups or of asylum seekers? Examples, victims of trafficking, victims of persons at risk, honour crimes, or other victims of GBV. I know that the Swedish Migration Agency also have a modified version in relation to religion. I know that EASO was using also to gender. So as I said, any refugee is all about the issues of difference. This is the case of DD, which I refer to in the first session. That's a victim of domestic violence from Albania, and Judge Perkins, in overruling an earlier case in 2004, made it quite clear that in that issue they didn't concentrate on the difference. It is that difference which provides the individual to come within the particular social group. So that's how it's been applied in relation to PSG. In relation to disability protection claims, even before DH, we had the case of W Zimbabwe in 2015, where the Home Office conceded at first instance that disability came under a particular social group. And if you look at the February-March 2016 ILPA mail shot, there is an example there, and there was a meeting with the NASA Equality subgroup, which we've got another meeting at 1 o'clock, on where it showed that it was also including the policy consideration. So here we have policy preceding change in relation to reported cases. I've had examples of cases where individuals have been HIV positive. A recent case of a Russian HIV positive gay man, where it was accepted in the decision letter that he came within the particular social group. So the DISH model was used in relation to these sort of cases. Now, regarding the DISH model, Newsweek reported about it in 2014 regarding that. It's a simple starting point that cuts across borders. Best practice. Don't wait till the interview. I hear a lot of narratives and anecdotal evidence. Well, the Home Office asked these questions and it's really, really unfair and my client wasn't prepared for it. I always advise my solicitors, my clients, when I'm doing direct access, to prepare the statement prior to the interview. Because usually with my clients, especially my direct access clients, it takes 2 to 3 months because you're going through the whole life story. And the majority of these statements are 20 to 30 pages long. They're writing their lives. So you have to give them that space to do so. And the solicitors I work with, they prepare the DISH model statement prior to interview, because a lot of individuals have no experience of being interviewed. So to go cold call into an interview where you're being asked questions in relation to your emotional journey, not to have the time or the opportunity to be able to explore that with those who represent you by telling your story, is clearly wrong, in my view. So the best practice is to produce a statement prior to interview. This is the most recent Home Office policy which I've access to, and that shows the equality impact at the bottom of that page, LGBT training, refresher training in line with the interviews with the DISH model. So that's very important that the Home Office show clear reference to that, and you see that on that slide. You have BM, a recent case of the Upper Tribunal by Upper Tribunal Judge Latter, where it's accepted in that case where a DISH model statement has been introduced at appeal level, that the Home Office policy was, you see that at 7C, is to consider that evidence in line with the DISH model, even though there had been earlier consideration of the earlier documentation. UNHCR IOM, as I said, 2015, 2012, it's endorsed in the International Protection Guidelines, number 9, and now since 2015 it's been used in all their field work. This is the 2016 reference, and you see the examples there. As I said, term difference and alternative terms to difference. This is the EASO ILJ 2018 guidance, and they use the DISH model also as an example in relation to a positive tool for credibility assessment. As I made it quite clear, it's not a negative tool to rule out a claim. because there clearly could be those who are LGBT who aren't able to provide a narrative which provides in line with the triggers and effects. Okay, that's very important, but it is a positive tool. So the DISH model there: difference, stigma, shame, and harm. We had the DISH model testimonials. You have Michael Ferguson there, Vanessa Delgado, and Adronke Apata. And I said, Adronke wasn't able to tell her narrative in a way she felt comfortable with, and she used the DISH model in August 2016 in her fresh claim, and the Home Office conceded her claim in August 2017. There is a book coming out. This is edited by Dr. Chelvan and Dr. Peter Dunn in December this year. I got the final proofs this morning. Chapter 4 is going to be looking at Adronke's case, and you can read more about the DISH model in that and how the impact of the policy changes happened here in the UK and internationally. So now I'm going to stop sharing screen and ask AXA to come back online. Hopefully we have some questions. AXA, do we have any questions?
Yes, we have one quite extensive question from Annika Dahlqvist, which is how to defend the DISH model against criticism. She says that claims that at times it can be perceived to be narrow, that people who do not fit into the model risk being robbed of the possibility to make their group membership likely. For example, a person who does not feel any negative feelings like shame versus someone who cannot talk about being different as they just came out. She says that for a very experienced officer, this can be taken into account, but for those less experienced officers, critics can say that this could be a restrictive tool, which without extensive training on LGBT issues might be something that migration agencies have difficulty in implementing.
Yeah, and the easiest answer to that and the very short circuit answer is to prepare the statement before the interview. Yeah, because that's where in effect, that's where people fall down. As I said quite clearly, that it's a positive tool, not a negative determinative tool to rule out claims, and that's very, very important to realise. So when you have the example where an individual's never felt shame, you go back to Article 1A2 and the definition of a refugee. So what is the basis of their asylum claim? Yeah, in what way have they developed? Because as we say, the development of identity is a precursor to, as the Refugee Convention, the recognition of difference is separate to the risk. So, it'd be very interesting to find out, to delve, to give the time to explore why that individual has never felt shame, but importantly, to look at the issue of difference. If they've never felt different, then that raises the quite important point as well. If you've never felt different, why are you claiming asylum? And that's why I said it's important to look at the views of the potential persecutor, to reframe the analysis away from the victim to the potential persecutor. Because if an individual has not ever felt different and don't feel that they will be treated differently in return, why they're suffering persecution. For an individual who's recently come out, as I said, there will be narratives in relation to that, and you'll have what is in effect is a plus claim. Somebody who's recently come out here in the United Kingdom. I had a Pakistani national who only realised these feelings because he went to a high school and saw two boys holding hands, and suddenly realised that's what I want to do. Yeah. So the recognition of difference, stigma, shame, and harm is actually transplanted from away from the home country to here. But it's very important that a lot of people talk about one of the critics of the DISH model say that, it's all about Western values and Western views. No, because the majority of the narratives is set within the context of the COI position and the personal experience in the country of origin. So that's very important. Great. So I'm looking at the time. We're right on the dot. So just to say that there are, thank you all for attending the second episode of the Migrant Law Clinic. There will be feedback forms which we circulated by the marketing team of that. Please do feel free to fill them in. And huge thanks to AXA for all her assistance today. And also huge thanks to Jonathan Lee in relation to his amazing work with the animation and the slides and everything, and very much so to the marketing team at Number 5, that's Becky and Liam and everyone, and also our clerks, Abdul and Gavin, who did some work behind the scenes in our chambers. So it's goodbye from me.
And goodbye from me.
Thanks a lot. Goodbye.